Thank you so much. Good morning, namaskar, dear panel colleagues, distinguished guests, ladies and gentlemen. It is a profound honor to be here in New Delhi to speak at the second New Delhi International Rule of Law Convention, and I'd like to congratulate the Bar Association of India, a very dear partner of the Brazilian Bar Association. For who doesn't know, the Brazilian Bar Association is the world's largest legal association with 1.4 million lawyers, 1.4 million members. So we have a very huge organization and with a very huge responsibility as well. So I'd like to congratulate the Bar Association of India in the person of its president, my good friend Prashant Kumar, for the wonderful arrangements for this event. It is also very good to see a lot of familiar faces and to see again my good friends from India, a country with a vibrant economic landscape and a sophisticated legal tradition, making it the perfect forum for this crucial discussion on capacity building in the legal profession of the Global South for commercial dispute resolution. I have spent the last 2 decades almost practicing corporate law in Brazil. I have been advising clients from several jurisdictions, from India to United States, France, Germany, China, Argentina, and others, on how to navigate the turbulent waters of an emerging economy, often mediating the intersection of local realities and international capital. This experience has shown me that while the geography of global commerce has shifted dramatically southward, the geography of dispute resolution has been slower to adapt. Today, I want to discuss how we as legal professionals in the Global South, especially, can bridge the gap, not by isolating ourselves, but by building the expertise and institutional credibility required to manage the complex disputes arising in our dynamic markets. Let us begin by acknowledging the established centers of international arbitration. These jurisdictions have earned their reputations. They offer neutrality, deep expertise, high-quality institutions, and a history of stable, predictable jurisprudence. As a practitioner, I respect and utilize these centers frequently. They set a global standard. However, the world economy in 2025 is fundamentally different than it was 30 years ago. The rise of emerging economies is not just a trend, it is a structural reorganization. The economic synergies between regions like Latin America and Asia, or Africa, and the Middle East are creating vast new corridors of trade and investments. This new reality demands a new approach for dispute resolution. Our goal should not be to replace the established centers, but to create a multipolar world of dispute resolution. A network of centers in the Global South that offer equivalent excellence, but with the added advantage of proximity in the contextual understanding. Capacity building is the roadmap to achieving this vision. Why does the status quo persist? Why, for example, do contracts between, say, a Brazilian agribusiness firm and an Indian importer often end up being governed by English law with arbitration seated in London, for example? It is a rational choice based on perceived stability and neutrality, but this choice carries significant hidden costs. The financial and logistical burdens are immense. For large multinationals, this is a merely cost of doing business, but for the small and medium-sized enterprises that form the backbone of our emerging economy, the cost of a complex arbitration in Europe can be existential. When a dispute regarding an infrastructure project in Brazil is adjudicated by arbitrators, however brilliant, who have never navigated the Brazilian bureaucracy and understood the nuances of our contract culture, something vital is lost. Decisions may be legally sound according to the black letter of the law, but particularly divorced from the commercial reality on the ground. The sheer volume of South-South economic synergies makes this deficit unsustainable. We need legal professionals and institutions that understand this context intuitively. We must transition from being mere importers of legal standards to developers of best practices tailored to the realities of emerging markets. How do we build this capacity, and more importantly, the trust that underpins it? The Brazilian experience offers some insights. 30 years ago, Brazil was viewed with a deep skepticism by the international community regarding dispute resolution. We were seen as protectionist and our judiciary as slow and unpredictable. The turning point was a concerted, systematic effort. It began with the legislative modernization, our 1996 Arbitration Act, based on the UNCITRAL model law. But laws are only as good as institutions that uphold them. The real catalyst was the evolution of our judiciary in Brazil. The Brazilian Superior Court of Justice, the STJ, adopted a decidedly pro-arbitration stance, consistently respecting party autonomy and efficiently enforcing foreign awards. Last but not least, in this topic, was Brazil being an early adopter of technology in the system of justice, meaning not only the judiciary, but also the legal profession, we lawyers and the law firms. Adopting virtual hearings since almost 10 years ago, virtual court sessions, generative artificial intelligence for legal documents and court decisions, predictive analytics, and a strong support of the adoption of alternative dispute resolutions, and also the online dispute resolutions, the ODR, including a mandatory mediation session before litigation case is initiated in the courts in Brazil. Brazil is also one of the world's largest hubs for legal techs, companies that provide technology solutions for the legal market and the judiciary. Furthermore, we recognize that complex commercial litigation requires specialized knowledge. We established commercial courts in major economic centers. These courts, with specialized judges, provide faster, more technically sophisticated decisions, increasing predictability for business. The key lesson is that building capacity is not just about training lawyers. It is about cultivating an entire legal ecosystem that international and domestic capital can trust. Looking forward, I propose 4 strategic pillars for capacity building across Global South. First, hyper-specialization. We cannot be just generalists. We must develop deep expertise in the section driving growth in emerging markets, commodities, complex infrastructure finance, energy transition, and fintech, for example. A lawyer who understands the intricacies of rare earth mineral extraction is more valuable than the one who only understands the abstract principles of contract law. The modern lawyer doesn't need to understand just law. It must understand the client's business. In the end of the day, we are all entrepreneurs, and our law firms are our companies. Second, institutional integrity and digitalization. We must continue to strengthen our regional arbitration centers, ensuring their governance rules and administration are impeccable. Trust is built on transparency and efficiency. Furthermore, we must aggressively adopt technology. Online dispute resolution that I said before, the ODR, is not just a tool for convenience. In the vast territories of the Global South, it is a vital mechanism for democratizing access to commercial justice, especially for small and medium-sized companies. Third, cultivating the cultural quotient. This is our unique competitive advantage. We must train our professionals to leverage their understanding of local cultures, negotiation styles, and socioeconomic context. Recognizing the unspoken dynamics in a dispute is often the key to resolving it effectively. This nuanced understanding is something external jurisdictions often lack. And fourth, the cross-border collaboration. While we respect the tradition of the Global North, we must invest more in the South-South exchanges. We need lawyers who are comfortable navigating the similarities and differences between civil law systems in Latin America and common law systems here in India and other parts of Asia and Africa. In conclusion, building legal capacity in the Global South is not a matter of regional or national pride. It is a matter of economic necessity. As emerging markets take center stage, the ability to resolve disputes efficiently, fairly, and with a deep understanding of the local context becomes a strategic asset. We recognize the value and contribution of established centers in Europe and elsewhere. They will remain vital hubs in the global legal architecture, and the emerging economies will keep using the arbitration centers. But the time has come to offer credible alternatives. By investing in hyper-specialization, institutional integrity, technology, and our cultural understanding, we can build a multipolar world of dispute resolution. This is not only serve our own economies, but to contribute to a more balanced, resilient, and equitable global economic system. Thank you very much.
Thank you, Mr. Bruno.